On the record in the matter of the people of the state of Michigan versus Uthman Ross, file number 23-03-567.
Good morning, Your Honor. Case Mark Aaron appearing on behalf of the people under Michigan Court Rule number 8.120.
Mr. Lee here today? Yes. I need all the attorneys here.
Right there.
Thank you. Counsel appearance on Mr. Ross.
Jacob Riley on behalf of Mr. Ross.
Today's date and time that was set for a final pre-trial. I have a Nolly here. The people are moving to dismiss. What is the reason for the dismissal?
Yes, Your Honor. At this time, the complaining victim has failed to appear, so the people would move to dismiss.
So the case is dismissed without prejudice. That means the people do have the right to reissue the charge against you if they later come in contact with the witness.
I'm going to read down for that, Your Honor.
Talk to your attorney about the statutory limitations. You can do that off the record, okay? Okay, do you have any other questions? Okay, and you're not untethered, correct? Okay, so there is a no contact order. You need to give us about 72 hours to remove that from lien, okay? Before you go into any zones or have any contact that was previously prohibited, okay? Okay, you're all set. We'll get you a copy of your dismissal. You're welcome. On the record in the matter of the people of the state of Michigan versus Sheena Marie Scott, file number 23-01015. Counsel appearance.
Good morning, Your Honor. Case Mark Aaron appearing on behalf of the people.
Morning, I'm Michigan on behalf of the defendant, Sheena Scott, who's standing to my right.
Okay, today was the date and the time that was set for a final pretrial. We do have contact from the complaining witness with the court. It looks like she contacted the clerk's office and that she woke up and her home had flooded. This is a matter, however, that has been previously set for final pretrial multiple times, it looks like. And the witness appeared. So are we proceeding to trial?
Yes, Your Honor. I don't believe we have a resolution on this one yet. I believe I did have some communication from Ms. Petrowski about the witness's appearance being pre-excused because of the appearances at the prior final pre-trials. That's not pre-excused. I would move for good cause to adjourn with the flooding or just set it for trial.
Okay, yeah, I'm not sure if it was previously excused because the January fifth note states that there was a stip in order to adjourn those dates. Uh, However, this matter has been set for final pre-trial multiple times and the witness or complaining witnesses has been present, so I wouldn't entertain a motion to dismiss for the purposes of her not appearing today due to a flood. So this matter is scheduled for trial February 27th at 8 o'clock in the morning. Any additional matters for today's record?
Nothing further from the people. Thank you, Your Honor.
And nothing further defense, Your Honor, thank you.
Thank you. We'll be prepared to go on the 27th. Okay, let me see here. The record in the matter of the people of the state of Michigan versus Rakan Aldegar, file number 23-00116. Council appearance.
Good morning, Your Honor. Case Mark Heron appearing on behalf.
Appearance, I'm on the record.
I'm sorry, I didn't know that.
Thank you. Are you representing him?
I am Assistant Public Defender John Lee on behalf of Rakan Aldegar.
We have an interpreter.
Yes, ma'am.
State your name, please.
Edward E. G.I.D.
Okay, raise your right hand. Do you solemnly swear or affirm that you will interpret in the matter now before the court completely and accurately and not divulge confidential communication, so help you God?
Yes, sir.
Thank you. Today's the date and the time set for final pretrial. My understanding is the necessary witness was approved to come at 1:30. There was an attempt to set this to 1:30, but that was unsuccessful on your part. There was an disorderly jostling.
فإنه في العقد له أو إنه لك مبادرة فإنك أنت تلغي الحكم أو
How does your client want to proceed?
Your Honor, my client is not interested in pleading guilty to anything. So if the complaining witness does make her appearance this afternoon, we'd like to, I'm sorry, his appearance this afternoon, we'd like to set the matter for trial.
Okay, so I'll note here, the matter will continue to trial. I will hold on to the file till 1:30. If the witness does not appear, the case will be dismissed. Do you have any questions?
No, he does not need to be here, correct, Your Honor?
He does not need to be here. You can call your attorney later to find out what happened. Any additional matters?
Nothing further from the people. Thank you.
Nothing for the defense. Thank you, Your Honor.
Thank you, you're all set.
Thank you.
Okay, let's handle Mr. Pruitt. I need a public defender to fill in for Mr. Pruitt. Did someone? Where's Mr. Lee going? Well, Mr. Mills, how are you?
I'm fantastic, Your Honor. How are you?
Can you do me a huge some favors today? Let's see. On the record in the matter of the people of the state of Michigan versus James Seaton, file number 23-03178, council appearance.
Morning, Your Honor. Case Markarian appearing on behalf of the people.
Good morning, Your Honor. Shanika Walker on the behalf of Mr. James Seaton. I'm filling in for Attorney Edward Zaney today.
Okay, and it's Mr. Seaton that's seated behind you?
It is, Your Honor.
Okay, today was the date and the time that was set for pretrial for operating while intoxicated, second offense. How are we proceeding? Is there an offer extended?
Your Honor, it's my understanding that we'll be setting this one for final pretrial. There's a little bit more review that needs to happen with this file and some issue with the length prior.
That is correct, Your Honor.
There's another amount of evidence, is that you're talking about that needs to be reviewed?
No, Your Honor, I think there might have been an issue with the charges.
Oh, okay. So I won't set it for final pretrial, I'll just set it for another pretrial to have the charges reviewed.
Thank you, Your Honor.
No problem.
What would that date be, Your Honor?
February 27th. 8:30. February 27th at 8:30.
Thank you, Your Honor.
No problem. Any additional matters for the record today?
Nothing further from the people. Thank you.
Nothing further, Your Honor.
Thank you. You're all set. On the record in the matter of the people of the state of Michigan versus Leo Bayard, file number 18-05724. Council appearance.
Morning, Your Honor. Case Markarian appearing on behalf of the people.
Very good morning, Your Honor. Attorney Brent Levine on behalf of Leo Baird. He's present. We both are via Zoom. Oh.
Okay, first and foremost, on the 18th, we advised your client that he needs to get his fingerprints done. To date, we don't have a completed fingerprint order.
All right, so let's go ahead and discuss that directly with my client. And I'm being transparent about this. I'm learning about this now, but I have no doubt that he did that. Leo, unmute your device, Leo.
My apologies. To be frank, I've been busy with work. Today's my first day off that hasn't been a weekend. I can get that done today.
Okay, I expect it done today, or otherwise I'm gonna have to revoke your bond for failure to comply with the court order.
Yes, Your Honor.
Okay, today was the date and the time set for a pretrial on operating while intoxicated. Was there an offer extended?
Yes, Your Honor. The offer was to operating impaired, but I believe we need to set this one for a plea date. I'll defer to Mr. Levine on that.
You need a plea date, counsel?
Thank you, Your Honor. We do. There's a little bit of an issue with the mechanics of the prior agreement, and we're working things through. Not a deal breaker. Enough to say that we do have a plea. We're just trying to fix it a little bit better. It's being, again, candid with the court.
Okay, so negotiations are still pending.
They are, Your Honor.
I'll note that in the file. I'll also note that your client will be at the court before 4 p.m. today to get his fingerprints done.
He will, Your Honor. He's committed to doing everything he has to. This was unintentional oversight on his behalf. He will.
Okay, I'll note that in the file. Let me get you a new date.
February
27th.
February 27th at 10.
27th at 10. Great. Excellent. That works. Thank you very much, Your Honor.
Any additional matters for today's record?
Nothing further from the people. Thank you.
Nothing from us either, Your Honor.
You're all set.
Yeah, thank you.
Thank you, Your Honor.
Lyman Hunter, is that reset? Okay.
Yeah, I'm here.
Can you start your video, please?
Huh?
Very good. On the record in the matter of the people of the state of Michigan versus Lyman Claude Hunter the fourth, file number 23-02677, council appearance.
Good morning, Your Honor. Casey Markarian appearing on behalf of the people.
Jacob Riley on behalf of Mr. Hunter.
Okay, Mr. Hunter, today was the date that was set for a pre-trial on malicious destruction of a building in a retail fraud third. We set this matter back in October because there was another case pending. Let's see, and there was possibility of a global resolution. Then we reset this again in December. Why are we requesting another adjournment?
Your Honor, I believe we are still trying to work out that global resolution from the prior case in circuit court. I believe we attempted to enter a plea in circuit court, but that plea failed, so now we're trying to resolve all that.
Okay. Okay, how much time do you need?
At least 2 or 3 weeks, Your Honor.
February 27th at 10 a.m. Mr. Hunter, do you have any questions for the court?
Not at this moment. Your Honor, this is bad. Lyman Hunter III. I do have a notice sent to the House regarding an arraignment for February 8th. That's Thursday, and I do have plans with my daughter. I don't even know what that's about, so I'm just inquiring.
I can come on in that, Judge. I know there's a new case that has been filed and Mr. Hunter is scheduled for arraignment on that date.
His attorney advises that he has a new case he's going to be arraigned on.
You say the attorney has advised?
He has a new case that's been issued against him and it's scheduled for an arraignment.
Is that in person?
It's a felony or?
It is felony.
Yeah, it's a felony. It's got to be arraigned in person.
Thank you.
You can, but just for your information, and you can always bring him in early to be arraigned. You can bring him in right now and we'll pull the file and arraign him.
Okie dokie. Thanks for the heads up. We have
No
no
problem.
knowledge about anything. All right.
Well, you got the notice that to appear for the arraignment, so that is knowledge.
Yes, that's all we have. We don't know knowledge about what.
That's all you're gonna get for an arraignment is notice of arraignment.
Okay.
So he'll come in, he'll meet with the public defender, and then they can get him arraigned. If you want to do that before the 8th because of your schedule, that's up to you. But if he doesn't appear on the 8th, then a warrant issues for his arrest.
We'll be there at 8:30 on the 8th. That's fine.
Oh, okay, sounds good. Any additional matters for the record?
Nothing further from the people. Thank you.
No, Your Honor.
Thank you. You're all set. Mr. Milkster, you ready?
I believe so, Your Honor. Let's see.
Okay, let me call one more. Have we seen Bernardo Perez Rosas?
Mr. Perez Rosas.
He's on Zoom.
Oh, he's on Zoom?
Yes. Can you just speak to him?
I don't think so. I think we said yes. We're ready to proceed.
On the record in the matter of the people of the state of Michigan versus Bernardo Perez Rosas, file number 23-03799, council appearance.
Casey Markarian appearing on behalf of the people.
Assistant Public Defender John Lee appearing on behalf of Bernardo Perez Rosas.
Mr. Perez Rosas Jr., can you hear me?
Yes, ma'am.
Very good. Today was the date and the time that was set for pre-trial. I have one count of child abuse, fourth degree, a domestic violence and an assault and battery. Was there an offer extended?
There was no offer extended at this time, Your Honor. I think that we might be able to work something out, but with the dynamics going on in this case, I just felt more comfortable leaving this one to the docket APA, Ms. Petrowski.
Okay, so do you want me to just reset it for another pretrial?
If you would, Your Honor, yes.
Okay, we'll set it for a new pretrial.
Thank you.
February 27th. February 27th at 8:30.
Okay, hold on. Let me write that down real quick, ma'am.
No problem.
Can you repeat that time again, ma'am, please, and thank you?
February 27th at 8:30.
February 27th at 8:30. Okay, that's appear in person, correct?
No, you can appear via Zoom.
Oh, okay, okay, ma'am.
You have any questions?
No, ma'am, I don't.
Additional matters for the record, counsel?
Nothing further from the people. Thank you.
Nothing.
We're all set. Thank you.
Thank you, ma'am.
Mr. Woolley, good morning.
Good morning, Your Honor.
Which matter are you here for?
Oh, nothing, not anything before you all.
Oh, okay.
Do I leave the Zoom meeting? Just wondering.
Yep, you're free to go. You give
Oh,
me just
okay,
a brief.
Oh, no, you're fine, ma'am. I was just wondering if there was anything else that I needed to hear or anything. But okay, I appreciate it.
Matter. Okay, let me remove Perez process. That's my only report. You need a copy?
I may after this, if I can get that later.
Thank you. On the record, in the matter of the people of the state of Michigan versus Edric Pruitt, file number 23-00590 FY, council appearance.
Casey Markarian, appearing on behalf of the people.
Good morning, Your Honor. Stephen Miltz on behalf of Mr. Pruitt. I'd also like to enter my appearance at this time on Mr. Pruitt's behalf for purposes of today's competency hearing.
Thank you, and I appreciate you jumping in the 11th hour for this purpose. This is a unique matter. Mr. Pruitt is present via Zoom at the Ingham County Jail. And this is a matter that has been pending. Charge has been brought against Mr. Pruitt, and we've not even been able to arraign him. And I think I misspoke when I said he's been in custody since August. He's been in custody since February on this matter with an account of assault on a prison employee. We've not been able to get him to comply for the purposes of an arraignment. And so we've not been able to properly appoint him counsel. And this is a matter that after several attempts to get him before the court entered an order for him to undergo a competency evaluation. We did have some issues with that because there was a refusal to participate, but it looks like they were able to complete a report and an evaluation. We have a report dated for January 30th, 2024, which we did provide to you, Mr. Mills, for the purposes of today's proceeding. And then the prosecutor also received a copy of the report, correct?
Correct.
Okay, the body of the report and the conclusion is that it was the opinion of the examiner that Mr. Pruitt does remain incompetent to stand trial, but they believe that there's a substantial probability that he could be expected to regain competency within the statutory time frame provided inpatient hospital setting and provision for appropriate therapeutic intervention. Any reason to object to the body or the conclusion of the report?
No objection, Your Honor.
No objection, Your Honor. It is my understanding, just for clarification, that he's charged with the 2-year felony of resisting obstructing.
I have here, at least in this file, a felony complaint that charges him in count 1 with assault of a prison employee, felony 5 years and or $2,500 in fine. I don't have an RNO, but that could maybe be something that stemmed from interaction while he was in custody. I'm not sure. I don't have that before me. Is there another matter opinion?
No, I'm sorry, Your Honor. If this was the 2-year offense that he's being brought under, then under the timing requirements, the time would have elapsed already, being 1/3 the maximum sentence. But since it's a 5-year, 1/3 would be 16 months, which then 15 months would, under the statute, would be less. So no objection to the report, Your Honor, regarding incompetency at this time. I'm sorry, I was referring to MCL .2034, parens 1, regarding the timing requirements there. But as the court advised me at this time, it is a 5-year offense.
Correct.
And so we'd be waiting for the 15-month period. My understanding is the court signed an order on May 9th of 2023.
For an evaluation?
Yes, sir.
That's correct, and he refused multiple times to comply with that order.
Okay. Thank you, Your Honor.
It looks like, okay. At this point, we're going to adopt the report incorporated as part of the court record, and I'm going to enter an order for him to undergo inpatient treatment for therapeutic or appropriate therapeutic intervention with the hopes of restoration of his competency. And see if we can get him arraigned if done within the statutory time frame. Let's see. Until that time, he'll remain in the custody of the Ingham County Jail. Any additional matters for today's record?
Nothing further from the people. Thank you.
Nothing further from the defense. I'm sorry. Was the forensic center going to have him go over to their facilities, or?
That was it looks like that's the intention, is for him to be placed in their facility for
We're
treatment.
just waiting on a bed at this point, I assume?
Correct.
Okay. Sorry, thank you very much.
No problem. Thank you so much again for assisting with this. Any additional matters for the record?
Nothing further from the people.
Nothing from the defense. Thank you, ma'am.
Okay, thank you, Ingham County Jail. He's all set.
I think he's.
I don't see him. That's for review.
Yeah, we're still off the record right now, Your Honor.
Yeah.
That's okay. I think the court had the privilege and honor of speaking with his father last time.
Oh yeah,
it was-
it's all coming back.
It's
Lovely people.
tumultuous case. And getting a hold of my client, blocks in the way, has been an issue. All I need at this point is him to sign the transfer documents, and we're good to send them over. I have significant problems getting hold of him.
Okay, well,
Can we put all that on the record?
well, we're not on the record, but I'm gonna go ahead and make sure and remand him. And then we can see what we do after that. Maybe he's with his dad, we don't know. Scary situation. Either way it goes, I guess. If you find him or get in contact with us, you'll let us know.
His dad does live in Washington, at least last I knew too, so.
Yep, that's what he told us when he cursed me out on Zoom.
Yep. Saw my notes from.
Wonderful. Thank you. Mr. Will, you can come around. I'm gonna meet you in the office. I'll be right back. Mr. Cooper, did you get your fingerprints taken care of?
My fingerprint,
Correct.
they're in the system, I haven't got them for this number.
You have to be fingerprinted on every time you have a charge against you. So there was an order that was issued, would have been issued back in October. Fingerprints. So can you go downstairs and do that and then come back?
Yes, ma'am.
Uh,
What do I do? Thank you.
Thank you. Thank you. You need to find. Clerks can give you the notice. You can, the clerk's office can get you the notice. Thank you. And that one's getting Nolly.
So yeah, I haven't seen the.
I might have crossed the Nolly out though. Okay, let's see.
Yeah.
Someone's, who's representing, Anissa Tijerina? On the record, in the matter of the people of the state of Michigan versus Anissa Marie Tijerina, file number 23-02267. Council appearance.
Case Mark Herring appearing on behalf of the people.
Assistant Public Defender John Lee appearing on behalf of Anissa.
Can you hear me, Ms. Tijerina?
Yes, I can, Your Honor.
Okay, very good. Today was the date set for his sentencing. I do have a pre-sentence report. It was prepared on January 30th, 2024. Did you get a copy of that, counsel?
I did, Your Honor.
Do we need to make updates, corrections, or deletions?
We don't have any updates, corrections, or deletions.
You can make allocution.
Thank you, Your Honor. Ms. Tijerina has at all times in this case accepted responsibility and cooperated in this matter. She has begun taking classes at Mid-Michigan Community College. She's taken 2 classes online, working her way towards a degree. She's currently employed at GC Services and has moved into a new apartment with her partner and has created a very sort of functional life for herself, Your Honor. So we're asking the court to take that into consideration when sentencing. We would also ask the court to consider either waiving any discretionary fines or costs or providing some assistance in the police recovery, which in this matter is fairly significant, $1,732. And we would ask the court to consider perhaps 1 class instead of 2. Again, given the fact that she's expressed remorse and taken responsibility, we feel 2 classes are a little bit redundant. But other than that, Your Honor, we have no other recommendations. We agree with most of what the PSI says and asks for, and I would ask the court to honor that.
Does your client want to make a statement?
You wish to make a statement, Ms. Tijerina?
I understand what I did was wrong and that I don't plan on doing what I did again. And I accept responsibility. I'm willing to do whatever it takes to, I guess, not rectify the matter, but prove that I understand what I did was wrong.
Thank you. I've reviewed the pre-sentence report, the recommendation, and I also reviewed the assessment. This is the only thing that you ever had on your criminal history, which is unfortunate. This is a situation that could have, just looking at the condition of the vehicle, could have killed you. This was a serious situation. Your blood alcohol content being more than twice the legal limit. The report for probation, however, indicates that you do not meet the criteria for an active substance use disorder. presented yourself to be respectful and remorseful at the time of your interview. I think that based on the assessment criteria and your criminal history, I don't even understand why recommendation is probation. If there's a presumption based on the law that we wouldn't, unless we had factors to go or deviate from that, we would not place her on a term of probation. I don't have those factors here, other than that her need or benefit from some classes that would help her better understand the dangers of driving under the influence. I think everyone should already, it should be automatic. It should be instinctive. We understand that if you drive under the influence, you could die. There can't be any more commercials, any more billboards, any more things that could trigger us to understand that that's a very dangerous thing to do, is to get behind the wheel of a vehicle when you're under the influence of alcohol. Even when you think you're okay. It's always when it's too late that you realize, actually, I wasn't as okay as I thought. And this is one of those situations, it appears to me, and just looking at, again, your virtually spotless criminal history. And it doesn't even appear that some of the other factors that we look for in an assessment are issues where you struggle with. You had low needs in all domains, it says. There was a moderate low need in family relationship, personality domains, but I don't see how probation addresses that. I think that although counsel, you may think it's duplicative, she needs to do both. She needs to do both the MAD impact piano within 120 days. She also needs to do the alcohol highway safety education program. She could have been proactive and done those before she got here today. But she didn't. This is a matter that took place in allegedly in July, and it's been before the courts in September. I don't know why the public defender's office shouldn't even be, they should be telling their clients to do these things proactively before they get here. This is what private counsel does. They send their clients, when they come to sentencing, they've already done this, so that they can say, look, Your Honor, this is what they've done to show that they understand the gravity of their actions and that she's learned from them, so that she won't do these things again. But I don't have those here yet. The restitution owed to the police, I am not, even if I had the authority to, I would never reduce, because it costs the taxpayers $1,732 to respond to the decision that she made, which was to get behind the wheel of a car and almost kill herself and wrap her car around a tree. And when you do that, that you got to pay for it. Why should we have to pay? Why should we as the taxpayers have to cover that cost? She needs to pay for it. And if that means she has to get a second job, then that's a decision she needs to make, because she made the decision to drive while under the influence. With that being said, I am not going to put her on a term of probation because I don't see how it's meaningful. I am going to, however, order that she does complete the MAD impact panel. I'm not giving her 120 days to do it. I'm giving her 60 days to do that. And she also needs to complete the alcohol highway safety education plan. I'm going to require that she provide proof of and evidence of the completion to that to our probation department again. Actually, I'll give her 90 days, within 90 days. And then I am going to order fines and costs and restitution. There's a $75 crime victim rights fee that per statute must be assessed, plus a $50 state minimum cost that also must be assessed. You owe the Lansing Police Department $1,732.83. I don't see where the prosecutor's office submitted any restitution, so that won't be ordered. Let's see here. we'll waive discretionary fines and costs because she's got a lot of cost recovery fees to pay. And she'll have to pay for classes or any fees associated with that. For total fines and costs, $1,857.83. And you'll be making monthly payments on that. You understand that, ma'am?
Yes, I do, Your Honor.
Okay, when do you think you'll make your first payment and how much?
Sorry, ma'am. I get paid. I can make it on Thursday of $150.
Okay, and then how often will you make payments? Well, you're gonna make it monthly, but are you gonna make payments of $150 each month? Or do you think that you need a lower payment so that you don't bind yourself up financially?
No, I'll be able to commit to $150.
So I'll note that she'll pay $150 each month.
Your Honor, is there a specific date that I am expected to be paying?
Well, you just say you're gonna pay on 150 this Thursday, the 8th, is that correct?
Yes.
Okay, so you'll make payment on the 8th of each month.
Okay.
You'll complete, again, Mad Impact. And the Alcohol Highway Safety Program within 90 days.
Okay, Your Honor.
Do you have any questions today for the court?
In the matter of paying, I guess I don't understand quite who am I paying? Like how
Well,
am
you'll
I?
make your payment directly to the court. You'll make your payment directly to the court, so you can come up and make payment at the criminal traffic window, which is right outside the court on the 6th floor. Or you can mail, check, or money order. You would put your case number on that 23-02267, and you can note that it's payment on your cost and fine. Or you can go on the court website. And once you go on the court website, you'll also use your case number, the 23-02267, and you can make payment online that way, okay?
Okay. Thank you, Your Honor.
No problem. Do you have any other questions?
Am I allowed to be in a breakout room with Mr. Lee?
Let's see, Mr. Lee, do you have, we'll have some people in the waiting room, and I don't know if Mr. Lee's representing them, but I can get you in a breakout room when he's available, okay?
Okay.
Okay.
Thank you,
Any
Your
additional
Honor.
matters for the record? No problem.
Nothing further from the people. Thank you.
Nothing for the defense. Thank you.
Thank you. Let's see who I have here. I have Monique Williams. That's your client, and I have Glenn and Jamie Irby. I don't think you're representing them. It's not, your name's not on there. And then I have a Jamie Brooks Hudson. Both of yours. Okay. Mr. Lee, you can go meet with Ms. Tijerina. You're ready on each of those?
Yes, sir.
Okay. On the record in the matter of the people of the state of Michigan versus Jamie Brooks Hudson, file number 24-00018, counsel appearance.
Morning, Your Honor. Case Morfarian appearing on behalf of the people.
Jacob Riley on behalf of Jamie Brooks Hudson.
Okay, Ms. Brooks Hudson, can you hear me?
Yes, ma'am.
Okay, today's the date and the time that's set for a pre-trial on a count here of assault and battery. Was there an offer?
Yes, Your Honor. There was an offer extended via email on this one to plead to a added count of disorderly jostling with a Killebrew agreement to no upfront jail in exchange for dismissing the assault and battery count. I believe that offer was denied, and we are setting this one for a final pretrial.
Okay,
That's correct.
we'll keep the offer open until the time of the final pretrial.
Yes, sir.
Final pretrial March 19th at 8 a.m. And then jury trial March 26th at 8 a.m.
Final pretrial will be March 19th, 8 a.m. in person at the court. And then the jury trial will be March 26th, 8 a.m. in person at the court. Mr. Brooks Hudson, do you have any questions?
Oh, no, I don't.
Again, the offer of disorderly jostling will remain open until the date of the final pretrial. Any additional matters for the record, counsel?
Nothing further from the people. Thank you.
No, you're right.
Okay, you're all set. Thank you.
Thank you.
Teacher Rita. On the record in the matter, the people of the state of Michigan versus Monique Monet Williams, file number 23-03798, counsel appearance.
Morning, Your Honor. Case Mark Aaron, appearing on behalf of
Jacob Rowley on behalf of Ms. Williams.
Ms. Williams, can you hear me?
Yes, I can.
Okay, today was the date and the time that was set for a pretrial on one count of domestic violence. Was there an offer?
Yes, Your Honor, there was an offer extended also via email on this one to plead to a added count of assault and battery with a Killebrew agreement for no upfront jail in exchange for dismissing the domestic violence count. I believe that plea was denied, and we are setting for final pretrial hearing.
Pretrial March 19th at 8.
Final pretrial, March 19th at 8 a.m. in person at the court. Jury trial,
March 26th.
March 26th, 8 a.m. in person at the court. Do you have any questions today, Ms. Williams?
No, I do not.
Okay, any additional matters for the record?
Nothing further from the people. Thank you.
Your Honor, thank you.
Thank you, you're all set.
Thank you.
Okay, are you ready on brief for the law?
Would it be possible to have just a moment with her to break down?
Yeah. No problem. On the record in the matters of the people of the state of Michigan versus Glenn Ray Irby, file number 23-03349, and Jamie K. Irby, file number 23-03350, counsel appearance.
Morning, Your Honor. Case Mark Aaron, appearing on behalf of the people.
Good morning, Your Honor. Sean Campbell on behalf of Mr. and Mrs. Irby.
Okay, today was the date and the time that was set retrial on dog malicious destruction of property, 2 counts each. Were there offers? I know we reset this because I guess negotiations or discussions were still pending.
Yes, Your Honor, there was a discussion at the last hearing for this one to plead to a civil infraction with restitution in the amount of $650 to the complaining victim, Jennifer Ray. I believe at the last one, we just reset this to allow for a receipt to be provided to the defense counsel on this. We have done that, and it's my understanding that they do intend to accept the offer.
Mr. Campbell?
I believe that's correct. My client to be willing to plead to 1 civil infraction dog at large and pay the restitution. Your Honor.
I don't know that civil dog at large is civil infraction under what code?
I may have miscommunicated there, Your Honor. I think it was just a 1 count of dog at large, not a civil infraction. My apologies.
Counsel, I didn't believe that a dog at large was a civil infraction because it's not. He said the offer was 1 count of dog at large, which would be a misdemeanor. Is that going to change your client's position?
Yes, it is, Your Honor, because I have an email from Casey Markarian, January 31st. Hopefully we'll be moving forward with the plea to a civil infraction with restitution. That was the email I received at ingham.org.
Yes, Your Honor, that was based on a note I have saying that the defense counsel had emailed Ms. Petrowski about a civil infraction. It was my understanding defense counsel would come prepared with the civil infraction they wanted to plead to.
Okay, well, impeding is sufficient for me. They're gonna do a civil infraction. Each will be entering or accepting responsibility to a civil infraction. Is that correct?
My understanding, sorry.
What's the amount of restitution?
$650, Your Honor.
Joint and several liability?
Yes, Your Honor.
Okay, Mr. Campbell, what was your understanding?
You were breaking up there, Your Honor. I apologize. I don't know if you can hear me well or not. My understanding was going to be 1 civil infraction with restitution for the $660.10.
Okay, that's my understanding, that each of them will be accepting responsibility to 1 civil infraction. So impeding as to Glenn Irby and then an impeding as to Jamie Irby.
So that's where the disagreement is. One of the parties would plead guilty to 1 civil infraction, which would incorporate the whole incident. So there'd be just one civil infraction against Glenn Irby and then pay the restitution.
Why? Well, was that offered that you would dismiss against 1 and only 1 would take responsibility?
That was not what I intended to convey with my offer. No, Your Honor, when I said that it was a civil infraction, I thought we understood that each case would need to have a civil infraction on it, since there was 2 counts of dog at large on each case.
Yeah, there's 2 counts of dog at large. They're both charged separately. They're not charged as 1 person. So he's offering each to take a civil infraction of impeding, because dog at large is not a civil infraction, and then $650 restitution, joint and several liability.
Your Honor, can I just clarify that with my client so there's no misunderstanding?
Yep, do you need me to put you in a private meeting room?
That would be great. And would you happen to know what the fine would be for that stated civil infraction?
130, let me double check. $130.
Per civil infraction.
That's correct. Each of them will have a fine of $130.
All right. Yes, I'd like a side room if we could do that. Thank you.
Okay. Back on the record in the matter of Irby and Irby. Counsel Campbell, did you discuss this with your clients and are they willing to proceed in that manner?
Yes, Your Honor, they are willing to proceed in that manner. They would just ask for as much leeway as far as the time to pay the fines. They can pay the restitution today, but they need a little leeway, as much leeway as you could give them for the fines.
Okay, so impeding traffic on each, again, the fine is $130. There's restitution, I need a restitution form. In the amount of $650, joint and severally liable. And that will be owed to the alleged victim in this matter. Who's the victim?
Jennifer Ray, Your Honor.
Okay, so Jennifer Ray, and they're gonna pay that today?
Yes, Your Honor.
You said
I have $36,000 in debt.
So what, mute whoever that is. Okay, and then how much time do they need to pay the fine?
What's the most the court would be willing to go out, I guess?
I mean, I don't like to go out too long because people forget about the fines, and then next thing you know, it's 2027, and we're trying to track them down for $130. So if they need to say they need 30 days and they'll make a payment of $25, I can do that. But I just need to know when they can make a payment, and it's got to be reasonable. I'm not setting this out 6 months for them to pay $130.
Okay. Would 3 months be agreeable?
Are they going to make payments during those 3 months?
Yes.
Okay, when are they going to make the first payment?
First 30 days.
How much a piece are they going to pay?
At least $30.
Is that something that you're able to do? You're gonna pay $30 in 30 days?
Yes.
Okay, so I'll note that you'll pay $30 by March 8th. That's for each of you, correct? And you'll make a payment on the 8th of each month of $30 minimum until paid in full.
Okay.
Do you have any questions about how you make those payments?
No, ma'am.
Any additional matters for the record, counsel?
Nothing further from the people. Thank you.
No, nothing, Your Honor. Thank you.
Thank you. You're all set.
Thanks. Have a good day.
Thank you. On the record, in the matter of the people of the state of Michigan versus Breeze Witherall, file number 21-02291, council appearance.
Good morning, Your Honor. Case Mark Herring appearing on behalf of the people.
Jacob Riley on behalf of Ms. Maduro.
Okay, Ms. Witherall, today was the date and the time set for a pretrial on an assault and battery. Was there an offer on this?
Yes, Your Honor. I'm in the process of writing a plea sheet for you now. The offer conveyed that is my understanding will be accepted is to plead to an added count 2 of disorderly jostling under MCL 750.1671L with a stipulation to a term of probation, mental health screening, and to follow all of the recommendations in anger management in exchange for dismissing count 1.
That's accurate.
Yes, that is.
You have anything else pending?
Let's have another matter in the 55th District Court. Which I believe is set for term selection. Understanding that court is treated essentially.
Gotcha. Okay, Ms. Witherall, that's accurate. You want to accept an offer to plead guilty to disorderly jostling with a stipulation, which is an agreement that you have that you will participate in a term of probation and be screened for mental health treatment?
Yes, Your Honor.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Thank you. You can put your hand down. Okay, Ms. Witherall, before you can accept this offer and plead guilty, you have to understand certain rights and you have to be willing to give these rights up, okay?
Yes, Your Honor.
That first right is your right to the presumption of innocence. So you're innocent until proven guilty. Do you understand that?
Yes, Your Honor.
You have the right to require the prosecution to prove your guilt at your trial. You have the right to a jury trial. The prosecution has to prove each element of the charge being brought against you beyond a reasonable doubt at the trial. You have the right to remain silent at trial and not have silence be used against you. You have the right to cross-examine or question and confront in court any of your accusers or witnesses that are called to testify at your trial against you. You have the right to subpoena witnesses on your own behalf to testify. You have the right to also present evidence at your trial that you believe show a defense of the charge being brought against you. Do you understand each of those rights?
Yes, Your Honor.
And are you willing to give up all of those rights today to enter a guilty plea to the added count 2 of disorderly jostling?
Yes, Your Honor.
Anybody threatening you to get you give up those rights?
No, Your Honor.
Has there been any promises made to you to get you to want to waive your rights and plead guilty?
What was that? I'm sorry, Your Honor.
Has there been any promises that are making you want to waive your right and plead guilty?
No, Your Honor.
Are you currently on probation or on parole?
No, Your Honor.
Do you understand that a guilty plea could result in a conviction that you may need to report to your current employer, or you may need to report this conviction on a future job application?
Yes, Your Honor.
And a conviction of this kind could also impact where you could travel on vacation or where you can get immigration status. Do you understand that?
What was that, Your Honor? I'm sorry.
If you plead guilty, this can result in a conviction that could impact what countries you can visit on vacation, or it could impact what countries you can get immigration status to. Do you understand that?
Yes, Your Honor.
Okay. As to the added count 2 of disorderly jostling, do you plead guilty, not guilty, or stand mute?
Guilty, Your Honor.
Are you pleading guilty because you believe you are guilty?
Yes, Your Honor.
Actual basis?
Thank you, Your Honor. Ms. Witherell, on or about August 18th of 2021, were you and your mother, named Teresa Jackson, present at or near 611 East Cesar Chavez Avenue in Lansing?
What was that? I'm sorry.
On or about August 18th of 2021, were you and your mother, Teresa Jackson, present at or near 611 East Chavez in the city of Lansing?
Yes.
Okay. At that location, did you get into an argument with your mother?
Sure.
Okay. Did you at some point assault your mother? Did you strike her physically?
Yes.
And this was not done in self-defense, is that correct?
Correct.
She didn't ask you to hit her or agree to it. In other words, she did not want that contact with her. Correct?
Sure.
Sure. What does that mean?
It's a yes or no.
Oh, yeah, sorry. I apologize.
Say,
Yes.
Any other questions?
Your Honor, would you be willing to take judicial notice that this was in Ingham County? Since we have the factual basis for the city of Lansing.
Okay, she's not sure where it was.
do you agree that this occurred on East Chavez in the city of Lansing?
Yeah, it's over nearby on a bar or something.
Okay.
Okay, thank you. Any additional factual basis?
Nothing further, Your Honor. People are satisfied.
Thank you. The court is also satisfied with the factual basis. I'll accept your plea. Finding your plea to be made freely, voluntarily, and intelligently. I'm going to set this matter for sentencing. do April 2nd at 9. April. We can do it sooner because I don't think she needs to be not supervision. Yeah, I don't need to necessarily refer her. I just have to set for sentencing because there's a victim.
Okay, February 27th at 9.
February 27th at 9. You have any questions for the court today?
No, Your Honor.
Any additional matters for the record?
Nothing further from the people, thank you.
Maybe address bond, Your Honor.
Sure.
Miss Witherell has been in custody since January 5th. She currently has no bond in this case. She's on remand. She does have a cash bond on her 55th district case. She tells me she would be able to post that if she were able to get a bond on this case as well. My request would be that a bond be reinstated, even if a GPS tether is required. I think Ms. Witherell would have no issue.
August 30th, 2021, defendant failed to appear. January 4th, 2022, defendant failed to appear. February 6th, 2023, defendant failed to appear. Flight risk. I don't want to keep looking for her. I want the matter resolved. We'll see you at your sentencing. Bond is denied. You're all set.
Great, but where's your house?
You have a written plea for the file.
Oh, yes, you can provide that.
You don't mean no, he needs to come in front of you after that. He got his fingerprints on.
You got another warrant?
Yeah, he got another warrant, but he got his prints done.
Ms. Donnelly, you're here with Gregory Brown Varian.
Yes, Your Honor. Can I get a breakout room with him before going on the record?
You have to join the breakout room. You should have received a request. On the record in the matter of the people of the state of Michigan versus James Minor. File number 23-03620. Mr. Minor, please start your video. Council appearance.
James Minor.
Assistant Public Defender John Lee appearing on behalf of James Minor.
Thank you. Mr. Minor, today's the date set for a pretrial on one count of domestic violence. Was there an offer?
There was an offer extended, Your Honor, but in communications with Mr. Lee, I believe Mr. Minor might not be eligible for the offer that was extended pending some results in circuit court. The offer was to 7694A, but it was made aware to me there is a pending case in circuit court with the same name victim. We are, I believe, seeking to push this one out to let the preliminary exam in that circuit court case happen. See what things go.
It's a preliminary examination of that.
March 8th, Your Honor.
We'll reset this. March 19th at 10. March 19th at 10.
March 19th at 10.
That's correct.
Okay.
Any additional matters for the record today, council?
Nothing further from the people. Thank you.
Nothing for the defense. Thank you.
Thank you. You're all set, Mr. Minor.
Okay, thank you.
You're welcome. What's this? I see Manuela Shearer is present.
Yes, ma'am.
Manuela Shearer.
I am representing the sheriff.
You ready to proceed?
Yes, we are.
On the record in the matters of the people of the state of Michigan versus Manuela Shearer, file numbers 23-03482838485. Council appearance.
Good morning, Your Honor. Case Mark Herring appearing on behalf of the people.
Assistant Public Defender John Lee appearing on behalf of Manuela Shearer.
Okay, Ms. Shearer, we reset these matters, which are all dog licensed in a one dog at large, so that you can get the VAX records. How are we proceeding?
Yes, Your Honor. It is my understanding, and we have received proof of via some email communications and some photographs that, so there are 4 charges total, 3 for dog license, 1 for dog at large. I've received proof of a new leash fence system to fix the dog at large issue. We would move to dismiss that charge this time. As for the other 3 dog license issues, it is my understanding that 2 of the dogs have been recalled. Move to dismiss 2 of those as well. And then for the third, it has been licensed. And the vaccine has been updated on that dog. That dog is named Juniper. So we would move to dismiss that charge as well. Total.
Okay, each matter is dismissed. You're all set, ma'am.
Thank you.
You're welcome. On the record in the matter of the people of the state of Michigan versus Gregory Brown variant, file number 23-03656. Council appearance.
Good morning, Your Honor. Case Mark Herring appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Sarah Donnelly on behalf of the defendant Gregory Brown variant, who's appearing separately by video.
Okay, today's the date and the time that was set for pre-trial. I have a police officer assault resistant obstructing and a domestic violence. Looks like back in December, we were here, but the prosecutors were looking to prepare a new complaint. So we reset this. How are we proceeding?
Yes, Your Honor, I believe the new complaint was prepared and we have extended an offer based on that new complaint. The new complaint should reflect the charges of attempt, R&O, resisting and obstructing, and DV fourth. The offer that was extended via email to Ms. Donnelly was to dismiss the attempt R&O in exchange for plain DV court, but I have not received any communication. I don't know if they accept that.
I don't see a new complaint in the file. Because it wasn't been updated on the sheet. We don't have a new complaint.
Your Honor, I don't believe I have an updated complaint either, and I just wanted to ask a point of clarification because did Mr. Markarian, were you saying DV court? Or just
DV court.
DV, domestic violence fourth offense.
Or excuse me, it should just be DV.
Oh, okay,
I
it says
apologize.
DV, it should just be DV.
Thank you.
Right.
Okay, no updated complaint, so I gotta reset this.
Okay.
February 27th at 10. Any additional matters for today's record?
Nothing further from me. Thank you.
Nothing for defense.
You're all set for today. Anybody see Kevin Kemp? Matthew Wolf did not appear. Did he get his fingerprints done? Wolf. No. Kevin Kemp Jr. Representing him.
Mr. Rowley said that he was looking for him earlier.
Okay. On the record in the matter of the people of the state of Michigan versus Kevin Kemp Jr. File number 23-00835, whatever's on your head, you need to take it off. Council appearance.
Sorry. Good morning, Your Honor. Case Markarian appearing on behalf of the people.
Jacob Rowley on behalf of Mr. Kemp.
Okay, today's the date and the time that's set for a pretrial on embezzlement. How do we want to proceed?
Your Honor, at this point, we would be requesting to reset the pretrial if possible. There's an issue with trying to determine the restitution and who's, there's a co-defendant on this case, so we're trying to decipher who's responsible for what amount. It's my understanding this is all on video. It's just going to take some time to go through the video. So it was open course about a month.
Oh, so you need about a month or two, you said?
No, Your Honor, I think the end of February date you've been giving might work.
Okay.
If we can get a little bit longer than that, I know there's going to be an issue with trying to figure out who's responsible for how much. Not sure what legwork has been done on this.
You said the end of February or end of March?
If we can get the end of March, I think we might need that time for this one, but we can make February work too.
Okay. March 26th at 10:30.
March 26th at 10:30. We'll get your notice to appear. Do you have any questions today? You look like you do. For the court though, not for your attorney.
I thought this was dismissed, and it looked like that's what one of my other lawyers had told me on the 3rd when I was in front of you. When I said embezzlement charge was dismissed. That's what I thought.
You said the felony charge?
Yeah, it was.
It probably was. This is a misdemeanor.
I'm sorry, he said the embezzlement.
Oh, the embezzlement charge. I don't know why someone would tell you that. Looks like you failed to appear back on April 6th. You were in bench warrant status until you appeared in December. You pled not guilty. This is my first time seeing you.
That's minimum.
I've never seen you on this.
Okay, that's.
So I'm not sure why you believe that it was, did you have anything else pending?
No.
Right, so you could, you should speak with your attorney off the record as to why you had the understanding that this was dismissed, but that's not what our record reflects. My record reflects is your very first court appearance on this. Any additional questions?
No.
Any additional matters for the record?
Nothing further from the people. Thank you.
No, Your Honor.
Thank you. Gavin Bombries. We've not seen him.
It's my client, and he has not appeared.
Looks like he's already in warrant status, so. Oh, this was someone back in November who was hospitalized due to gunshot wounds.
That's right, we did adjourn once for that reason, but however, I've not been able to reestablish contact since then.
Okay, and you have a number ending in 1756.
Check my records. Sure. Yes, the number ending 1756.
Oh, I'll shoot a bench warrant. That's all I have for the morning. Oh, I have been holding these. One is for this afternoon.